Have you ever had a brilliant idea, something truly innovative, and wondered if it was truly yours in the same way your physical possessions are? It is a fascinating question that touches upon the very essence of liberty and ownership. Within libertarian thought, whether ideas qualify for ownership under the principle of self-ownership is a subject of significant debate and does not have a single, universally accepted answer. While the concept of self-ownership affirms absolute control over one's body and labor, extending this directly to abstract ideas presents unique challenges and divisions among theorists. The core of this complexity lies in how we define and interact with ideas compared to physical property. Proponents of intellectual property rights, or IPR, often argue that an idea is the product of one's mind and labor, and therefore, an extension of self-ownership. They might contend that just as you own the fruits of your physical labor, you should own the fruits of your intellectual labor, which are your original creations and inventions. This perspective emphasizes the incentive for innovation and creation, suggesting that without ownership, creators would have less reason to invest time and resources into developing new ideas. However, critics within libertarianism raise important distinctions. They argue that ideas, unlike physical goods, are non-rivalrous. This means one person's use of an idea does not prevent another from using it simultaneously. If you use my hammer, I cannot use it. If you use my idea, I can still use it. Furthermore, ideas cannot be physically enclosed or easily controlled in the same way land or objects can. They suggest that once an idea is expressed, it enters the commons of human knowledge, and attempting to restrict its use through artificial monopolies like patents or copyrights, which are enforced by the state, is a violation of property rights in other areas, such as the right to use one's own resources to reproduce an idea. Understanding this debate means examining the fundamental principles involved. To evaluate arguments for and against intellectual property, consider the non-aggression principle, or NAP, which states that initiating force against another person or their property is wrong. Ask yourself if preventing someone from using an idea they independently arrived at, or that they learned from you and wish to implement with their own resources, constitutes aggression. Also consider whether granting exclusive rights to an idea creates a coercive monopoly enforced by the state, rather than a natural property right derived from labor and self-ownership. A key term often used in this discussion is homesteading, where individuals acquire unowned resources by mixing their labor with them. While homesteading clearly applies to physical resources, its application to ideas is highly contentious. Some argue that the act of creation is a form of homesteading the intellectual landscape, while others counter that ideas, by their nature, cannot be unowned in the same way a piece of land is. They believe that ideas exist in a different category entirely, perhaps more akin to mathematical truths or logical principles, which cannot be exclusively owned. This distinction between rivalrous and non-rivalrous goods is central to understanding the different positions. Ultimately, whether ideas qualify for ownership under self-ownership in a purely libertarian framework remains an open philosophical question, inviting careful consideration of what constitutes property, the nature of intellectual products, and the role of coercion. The goal is to maximize individual liberty and foster innovation, whether through exclusive intellectual property rights or through free and open access to information and creativity. It encourages us to think critically about how best to respect individual autonomy while promoting human progress.